Good evening. I usually have such a loud voice that I find myself in a very unusual position. We meet today on the traditional lands of the Wurundjeri people of the Kulin Nation, and we pay our respects to their elders past and present. My name is Pip Nicholson. I'm the new Dean here at the Melbourne Law School, and it is an extraordinary pleasure to meet so many of you here tonight. I welcome Your Honours, ladies and gentlemen, and I ask you to sit back and relax and to thoroughly enjoy the presentation by Professor Philippe Sands. Before I go on to say a few words about Philippe, I would also like to acknowledge the Arts Centre Melbourne, who have been instrumental in instigating and arranging Professor Sands' visit. And I'd also like to express my deep gratitude to the generous funding provided by the Nathan and Pamela Jacobson Trust. To all those parties, we are indebted for tonight's oration. Let me now turn to Professor Sands. I might just add that in talking with Philippe a moment ago, he said he felt extraordinarily at home at the Melbourne Law School. And so I see tonight as a continuation of a conversation we've had with Professor Sands and his work over a long period. And for that, we're very grateful. But for those of you who perhaps are less familiar with Philippe, he is a Professor of Law at University College London and a barrister and arbitrator at Matrix Chambers. He is the author, of course, of many academic works on international law and indeed humanitarian law, but also works and publishes widely as a well-loved and well-known public intellectual, contributing to the New York Review of Books, Vanity Fair, and the Financial Times and The Guardian. His latest book, which will clearly be referenced in tonight's presentation, is East-West Street, on the origins of crimes against humanity and genocide. It was the winner of the 2016 Baillie Gifford Samuel Johnson Prize and the 2017 British Book Awards Non-Fiction Book of the Year. It is accompanied by a BBC Storyville film, My Nazi Legacy, What Our Fathers Did, and he is now writing, I understand, the sequel. Philippe is also the Vice President of the Hay Festival and a member of the board of English PEN. We are extraordinarily grateful to you, Professor Sands, for coming tonight, to opening up your story and to sharing the interpretation that you wish to with the audience assembled here. Welcome.
Dean and colleagues from Melbourne Law School and many friends in the audience. It is actually true what I said, Pippa. I've been in this room many times and I've taught here, and it's a very special place for me. I always feel incredibly at home in Melbourne. Well, I'll put it this way, I feel incredibly at home in Australia, especially at home in Melbourne. And of all the places, Melbourne Law School is the one that is the most at home. So you've mentioned my book, East-West Street, which took nearly 7 years to write. It's about the lives of 4 human beings, 4 men, and the book seeks to understand how their particular circumstances contributed to the roads each of them took, and how the roads they travelled changed the story of international law, which is my daily work. But the book also touches, as many of you who've read it will know, a much more personal theme, namely how these 4 interweaving lives influence the path that I've taken, whether directly or indirectly, and the confluence of those 2 aspects, the public and the private, addresses, I think, a bigger question which is at the heart of the book. It's a question of identity, and it asks the question that each of us asks: who am I? an individual or a member of a group? And how do I wish to be protected? Because of my inherent qualities as a human being, or because I'm a member of one or more groups that is under threat? The book came about entirely by chance. In the spring of 2010, an invitation arrived in my computer from the Ukraine, from the law faculty of the university in the city that used to be called Lemberg up until 1918 and the end of the Austro-Hungarian Empire, and then Lvov when it became part of Poland until 1939, and then, after 1945, Lviv in the Soviet Ukraine. Would I come and visit and deliver a public lecture on my work on crimes against humanity and genocide, and on the Nuremberg Trial? Yes, I said, I would. I'd be delighted to. I've long been fascinated by the trial and all the myths of Nuremberg, by the words, the images, the sounds, the lengthy transcripts, the terrible evidence, the memoirs, the diaries, and films like Judgment at Nuremberg, which is a film that won the Oscar in 1961 and made memorable for many reasons, but not least a fantastic, unexpected, momentary flirtation between Spencer Tracy and Marlene Dietrich, and Spencer Tracy's fantastic closing lines from his final judgment at the end of the film. And I quote, "We stand for truth, justice, and the value of a single human life." But there's also the fact that the Nuremberg judgment blew a powerful wind into the sails of a germinal human rights movement. And it opened the possibility, for the first time in human history, that leaders of a country, the sovereign, could be put on trial before an international court. That had never happened before, ever. It's probably my work as a barrister rather than as an academic, my writings, that caused the invitation to be sent. In the summer of 1998, I'd been peripherally involved in the negotiations in Rome that led to the creation of the International Criminal Court. I, with my friend Andrew Clapham, was asked and tasked with drafting the preamble to that statute. The court has jurisdiction over genocide and crimes against humanity and a couple of other crimes. The essential difference between the two concepts relates to who is protected and why. Assume that 10,000 human beings are killed, murdered, exterminated. The systematic killing of such a large number of individuals will always be a crime against humanity. But will it be a genocide in international law? That depends on the intentions of the killers and the ability of a prosecutor to prove those intentions. To establish the crime of genocide, you have to show that the act of killing is motivated by a special intent, the intent to destroy a group in whole or in part. If a prosecutor can't prove that special intent, then genocide will not, as a matter of law, have been established. And so you've got these two concepts operating side by side and overlapping. Every act of genocide will be a crime against humanity, but not every crime against humanity will be a genocide. And that difference has given rise to a pecking order in the eyes of many people, including many people in the public, and I suspect also in this room. Genocide has come to be seen as the crime of crimes, somehow more serious than any other. In the years that followed the Nuremberg judgment, the gates of international justice creaked open very slowly after 5 decades of quiescence during the Cold War chill that followed Nuremberg. Cases from the former Yugoslavia and Rwanda landed on my desk in London, and others followed, a long list. Congo, Libya, Afghanistan, Chechnya, Iran, Syria, Lebanon, Sierra Leone, Guantanamo, Israel, Palestine, Iraq. It's a long and sad list, which reflects the failure of good intentions, aired in Courtroom 600 in Nuremberg. I became involved in too many cases that involved mass killings. Some were about crimes against humanity, the killings of individuals on a large scale. Others gave rise to allegations of genocide, the destruction of groups. These two distinct crimes, with their different emphases, grew side by side, although, as I mentioned, over time, genocide seems to have emerged in the eyes of so many as the crime of crimes. Occasionally, in my work, I'd pick up hints about the origins and purposes of the two terms and the connection to arguments that were first made in Nuremberg's Courtroom 600, starting on the 20th of November 1945. But I never really dug into the personal details. And so the invitation from Lviv offered a chance to do exactly that. Now, I could say that I accepted the invitation because I wanted to give a lecture, but that would not be truthful. The real reason is because I went because of this person who happens to be my grandfather, who was born in Lemberg in 1904. His name was Leon Buchholz, and he called it Lemberg when he spoke in German, and Lwów when he spoke in Polish. In his wonderful slim volume, Mój Lwów, My Lviv, which was written in 1946 and now available in English for the first time under the title City of Lions, the Polish poet Józef Witlin, who arrived as a refugee in New York in 1946, describes the essence of being a Lwovian. It is, he writes, an extraordinary mixture of nobility and roguery, of wisdom and imbecility, of poetry and vulgarity. But he ends his essay with a line: I know people for whom Lwów was a cup of gall. And it was a cup of gall for my grandfather, a place that was buried very deep in his consciousness, part of a hidden hinterland of which he never, ever spoke to me. His silence barely covered the wounds of a family that he left behind in 1914 when he moved to Vienna, when the Russians invaded the city of Lemberg, and then lost forever in 1939. But the very first moment I set foot in that city in the autumn of 2010, accompanied by my mother, my aunt, and my 15-year-old son, the place felt incredibly familiar. It was like meeting a long-lost relative. I was interested in the psychoanalytical aspects of my relationship with the city and with my grandfather. And I asked a couple of psychoanalysts to recommend me work about the relationship not between parent and child, but between grandparent and grandchild. And it is the subject of intense attention these days by psychoanalysts. I was referred to the work of two Hungarian psychoanalysts, Maria Torok and Nicholas Abraham, who wrote that what haunts are the gaps left within us by the secrets of others. And those are the words with which East West Street opens. My grandfather's secret, which he never talked about, was that he came from a huge family that was centered in Lemberg and its environs. That family grew and grew until 1939, when the war came to the city. And from the spring of 1945, by which time he was living in Paris, he lived the entirety of the rest of his long life, more than 50 years, believing that he was the only survivor from the city and from the province of Galicia. In 1939, he was expelled from Vienna simply for the reason of being a Jew. He went to Paris. That's where he lived when I came to know him. I had always assumed that he left Vienna with his wife, Rita, my grandmother, and his one-year-old daughter and only child, Ruth, my mother. But in the course of the research in preparing for the trip, I was given by my mother for the first time family papers that I had never seen before. And I learnt immediately, I was given access to those papers, that my belief was inaccurate. Leon left Vienna and made his way to Paris by himself. Only now, having access to these personal papers, did I learn that his daughter, my mum, travelled to Paris a few months later, in July 1939, and did so by herself. How does a one-year-old child get from Vienna to Paris? And then I learned that his wife, my grandmother, chose, or did stay behind in Vienna for 3 more years. And from these materials, perhaps with a litigator's instinct, I sensed that something else had intervened in their lives before they separated in January 1939. Why did Leon leave Vienna on his own? How did my mother get from Vienna to Paris as an infant of less than a year? Why did Rita remain in Vienna, allowing herself to be separated from her only child? Every parent in the room, and in particular every mother in this room, will understand the complexities that that would give rise to. These were big questions, and they hung in the air. I returned time and again to the documents that I found in my grandfather's papers, looking for clues. As a litigator, which is a sort of lesser amateur historian come psychiatrist, you learn that every scrap of paper or photograph is capable of, and invariably does, hide information that is not immediately knowable. This is the muck of evidence, and I love it. Look carefully, I have learned. Keep an open mind. Attend to the unexpected. Find the dots. Try to join them. Challenge your assumptions, and persist. Nothing is ever only what it seems. And 2 items stood out. The first was a tiny, small scrap of thin yellow paper. It looks here as though it is vast, but it's only 1.5 inches by 1.5 inches. It was folded in half. One side was blank, and the other bore a name and an address written firmly in pencil. The writing was angular and strong. It said, Miss E.M. Tilney, Manuka, Bluebell Road, Norwich, Angleterre. The second thing that drew my attention was a small black and white photograph, not much larger, taken in 1949 and not quite square. It showed a middle-aged man staring intently into camera. On the back of the photograph, in blue ink, was written the words, Herzliche Grüße aus Wien, September 1949. Warmest wishes from Vienna. And there's a signature, indecipherable. The writing was firm, but I couldn't work out the name of this person. When I first saw these items and asked my mother who Miss Tilney was, she said she didn't know. And when I asked her who the man was, she said she didn't know, but I didn't really believe her. And I retained the scraps, stuck them above my desk, wondering whether they might shed some light on what really happened to my grandfather in 1939. I pinned them above my desk, and they stayed there for 4.5 years, and turned to the lecture that I had to write. Now, I've taken you off on a little personal detour, something we're not supposed to do as legal scholars or as practitioners. But you will recall that the lecture that I was to deliver was on war crimes, on crimes against humanity and genocide. So let me take you to the first of a number of coincidences. In preparing that lecture in the summer of 2010, I was enormously surprised to discover or learn that the man who put crimes against humanity into international law came from Lviv. Indeed, he was a student at the very university that had invited me, and the people who had invited me were unaware of that fact. His name was Hirsch Lauterpacht, probably the greatest international lawyer of the 20th century. And he was born in the small town of Zhulkiev, about 15 miles north of Lviv. He moved to the city when he was 14 years old in 1911 and enrolled at the University Law Faculty 4 years later. In 1919, he moved to Vienna. He did his doctorate with a group of people and befriended and came to know Hans Kelsen. 4 more years of study there, and then to London in 1923. He became a renowned academic, first at the London School of Economics and then at Cambridge University. And in 1945, he published a book that laid the foundations for our modern system of human rights. It was called An International Bill of the Rights of Man, and it offered what at that time was an absolutely revolutionary idea, that every individual had minimum rights under international law. That was an idea that was novel. It did not exist before 1945. He even wrote out a draft Bill of Rights, which was intended to give effect to his credo that the individual human being is the ultimate unit of all law, including international law. In April 1945, after the war in Europe ended, Churchill, Roosevelt, and Stalin agreed that there would be a criminal trial for senior Nazi leaders. The British hired Lauda to assist in the prosecution, to work with Robert Jackson, the chief prosecutor in the Nuremberg trials. In July 1945, Jackson travelled from the US to England and to London to draft the Charter of the Nuremberg Tribunal. The 4 powers, the US, Britain, France, and the Soviet Union, disagreed about the crimes over which the new tribunal would exercise jurisdiction. On July the 29th, 1945, Jackson was driven from his hotel, Claridge's, in Mayfair to Cambridge to have lunch with the Lauda on Cranmer Road, right opposite the Research Centre for International Law. They would sit together in the garden at Cranmer Road. I rather love this photograph of Lauda sitting in his garden in 1945. And they have tea together. I've wondered sometimes what they had for tea. And in some versions of this lecture, I speculate on whether it was a Victoria's sponge cake from Fitzbilly's. And most people tell me afterwards, why do you mention that? No one knows what Fitzbilly's is. But in this morning's Guardian newspaper, there is an interesting article about the Cambridge historian Mary Beard, in which the cake from Fitzbilly's becomes a central issue in a fight she is having currently with another Cambridge academic about colonialism and language. Jackson and Lauda talk about the list of crimes and the problems that it's going to cause. Lauda has a couple of ideas. He suggests to Jackson that it would be a good idea to introduce titles into the statute. He says that would help public understanding, and more public understanding would give rise to greater legitimacy to the proceedings. Jackson reacts positively to the idea, and so Lauda offers another idea. He has a particular academic interest on the protection of civilians. He's long written about this, but he also has a personal interest in the matter because his parents and whole family remain unaccounted for in Lemberg. He has no news about his family. But of course, being an emergent Englishman, he says nothing at all about the personal side to Robert Jackson. Why not, he says, why not refer to the atrocities that are being committed against civilians as crimes against humanity? You can see the words here in his own handwriting. The term, as Lauda conceived of it, would cover atrocities against individuals committed on a large scale, torture, murder, disappearance, and introduce a totally new concept into international law. On August the 8th, 1945, the words crimes against humanity are incorporated into the Nuremberg Charter as Article 6, paragraph C. Preparing for the lecture in Lviv also required me to focus on the concept of genocide. And this brings me to a second surprise. The man who invented that word just a few months earlier, in November 1944, also passed through Lviv and also studied at the same law school in the same university as Lauda. His name was Raphael Lemkin. No one at the university who had invited me was aware of that fact either. He arrived at Lvov University in 1921, 2 years after Lauda left, and by 1926 he'd obtained his doctorate in criminal law. After law school, he became a public prosecutor in Warsaw, and in 1933 he wrote a paper for a League of Nations meeting in Madrid and proposed a new international crime to combat what he referred to as barbarity and vandalism against people. His focus, unlike Lauda, was not on individuals, but on the protection of groups. The timing was not good. Hitler had come to power that very year, and the ideas sort of bounced around and disappeared. In 1939, when Germany invaded Poland, he was in Warsaw. He escaped, made his way to Sweden, remarkably taught himself Swedish in 6 months to a sufficient proficiency to give a series of lectures on Swedish commercial law and write a book about that subject. And then in 1941, made his way as a refugee to the United States and to Duke University and Durham, North Carolina, where he was given a place as a visiting academic. On this lengthy journey, 3/4 of the way around the world, because the Atlantic was shut, he had to travel via the Soviet Union and Japan. He traveled with virtually no money at all and no personal possessions, but a huge quantity of luggage. The luggage was filled with pieces of paper, thousands of decrees promulgated by the Nazis in occupied countries. He'd gathered these materials starting in Stockholm and carted them around the world. In fact, no one had known which Swedish company and which Swedish individual had helped him gather this material, but just this morning I received an email from a Swedish writer and academic who has given me what he believes to be the name of the company and even the name of the individual who he believes to have worked with Lemkin, so it's quite an exciting day today. In the United States, he analyzes the decrees, and in 1942 is offered a contract to write a book by the Carnegie Foundation that will describe the patterns of behavior that he has found in these thousands and thousands of decrees. He's looking for indicia of a master plan. The book is published in November 1944. It is given the unattractive title Axis Rule of Occupied Europe, and Chapter 9 is given as its title a word which he has invented, genocide. This is the writing of Lemkin, which is interesting in its own ways. Genocide refers to the crime of the destruction of groups, and it is an amalgam of the Greek word genos, meaning tribe or race, and the Latin word side, which means killing. In the summer of 1945, he's hired by the United States government to work on war crimes, and he begins to work with Robert Jackson and his team, although in a completely separate role from Lauda. And he pushes his idea of genocide, a crime which he's a little bit obsessive about, and for which he wants the senior Nazis to be indicted. In August 1945, when the Charter of Nuremberg is adopted after Jackson's visit to Lauda in Cambridge, Lemkin is deeply disappointed that it includes crimes against humanity, but makes no reference to genocide, or indeed to the destruction of any groups. So he flies to London, where the indictment against the individual defendants is being drafted, and persists, pressing for genocide to be included in that document. There's tremendous opposition from Jackson's office to the concept of genocide, largely under pressure from southern United States senators who are concerned about discrimination against African Americans and the use of that term in that context, but also from the British, who are concerned about the colonial legacy and its use by some of the victims of that legacy. But somehow, against the odds, Lemkin's word makes it in to the indictment. He is described by the son of Robert Jackson as a persistent bugger, and he gets it in. He describes himself as greatly pleased. The indictment alleges that the Nazis conducted deliberate and systematic genocide, and this is the first time that the word is used in any international legal instrument, and it comes with his definition: the extermination of racial and religious groups, and it mentions explicitly Jews, Poles, Gypsies, and others, and it applies to the ill treatment and murder of civilians in all occupied territories, including Lemberg and Volkovysk, which is now in Belarus, where his parents live. But like Lauda, he's got no news at all about the fate of his own family. On October the 18th, 1945, the indictment is filed at the tribunal. I went to London, he will later write, and I succeeded in having inscribed the charges of genocide against the Nazi war criminals in Nuremberg. The Nuremberg Trial opens on November the 20th, 1945. Lauda is present in the courtroom with the British team pushing for the protection of individuals, but Lemkin has been told to stay in Washington, from where he pushes from a distance for the concept of genocide. One of the 22 men in the dock is this man, Hans Frank, who becomes the fourth man in East Westridge. He too is a lawyer who, from the late 1920s, 1928, served as the personal lawyer of Adolf Hitler. In 1933, he was appointed Bavarian Minister of Justice, and a couple of years later, he set out his credo at a conference of lawyers and international lawyers in Berlin. Community, he said, takes precedence over the egoism of the individual. In his case, that precedence would give rise to mass killing on an industrial scale. In October 1939, he became Governor General of Nazi-occupied Poland, and in August 1942, he visited Lemberg and Galicia, which was newly incorporated into his territory. He hosted a series of concerts which finished with Beethoven's Ninth Symphony, and gave a series of speeches in which he announced the implementation of the Wannsee Conference final solution and the elimination of the city and the region's entire Jewish population, 500,000 human beings. Amongst those who will be caught up in the horrors that begin just a few days later are the families and friends and teachers of Lauda and Lemkin, as well as my grandfather's family. For each family, there will only be a single survivor. In this way, Hans Frank becomes the connector between the three lives. 3 years later, in May 1945, Frank is caught by the US Army near his home south of Munich. He has with him his diaries, 42 volumes, and a fantastic collection of artwork. And when I say fantastic, I mean fantastic. It includes this painting, which some of you will have seen in Poland or at the National Gallery in London when it visited, Leonardo da Vinci's portrait of Cecilia Gallerani, the lady with an ermine, which was painted around 1489 and hung in a museum in Krakow until he arrived. He took it and put it in his personal offices at the Wawel Castle in Krakow, where it is hanging again today. Frank's son, Nicholas, who I have come to know, told me that when he was a young boy of 5, his father would make him stand in front of this painting and slick down his hair like Cecilia Gallerani, and the little boy was always scared because he thought the animal was a rat. Frank now is in the dock and accused, and he's charged with crimes against humanity and genocide. On the first day of that trial, the Soviet prosecutor takes the judges, to what happened in the city of Lviv. He describes the murders and the tortures and the ill treatment, concentration camps and other establishment in what he describes as the eastern countries. and he calls them acts of genocide, explicitly evoking the events in Lemberg in August 1942, in the days that followed Frank's visit. More than 130,000 people tortured and shot in just a few weeks, he tells the tribunal, including 8,000 children killed in just 2 months at the Janowska camp, right at the heart of the city of Lviv. As those words are spoken, Lauterpacht and Lemkin, members of the prosecution team, do not know whether the victims include their families, and they are not aware, when the trial opens, that the man they are prosecuting, Hans Frank, could be implicated directly in the fate of his own family. That is a fact that I think about a great deal in imagining how it must have been for the two of them to have been involved in that trial. Now, on that day, the 20th of November 1945, for the first time ever, the terms genocide and crimes against humanity are used in open court. I know Lauterpacht and Frank to be in the room on that day, and I wonder if there is a photograph of that. Lauterpacht's son Ellie, who I've come to know well, tells me that there is no family, but no photograph, but rather like my mother, I don't believe him. And I persist, there must be a photograph. I spend more than a day at the archives of Getty Images, which holds the largest archive of Nuremberg photographs. And I go through hundreds, literally, of old glass plate images, each of which is in its little paper envelope, has to be taken out and looked at under one of the special cameras. And after several hours, I finally find what it is that I'm looking for, a magnificent photograph taken from an unfamiliar angle. A hole was cut in the wall in the courtroom to allow one cameraman to poke a lens through it. You can see Lauterpacht sitting at the end of the British table. Second on the left, elbows on the table, hands clenched under his chin. And looking at that photograph, I often wonder what was going through his mind. He's attentive, he sits directly behind the Soviet Council at the lectern. And if you go to the lower right-hand corner, you'll see the large figure of Hermann Goering in an oversized light-coloured suit, and then move along the bench to his left, 6 along, and just before the image is cut by the protruding balcony, you see the semi-bowed head of Hans Frank, divided by no more than a few tables and chairs with their very different histories and backgrounds and roles. Lauterpacht and Frank are together in the same room. As many of you will know, the trial lasts for a full year, and judgment is handed down over 2 days, over September the 30th and October the 1st, 1946. The 70th anniversary was marked a couple of years ago in Courtroom 600 in Nuremberg's Palace of Justice, and the performance which we're doing tomorrow in Hamer Hall was performed on that anniversary, I have to say rather remarkably, with the last 4 living survivors of the trial sitting in the front row. It was an incredible thing to be in that room with them and to talk to them about what it was like in the trial. I hope you might understand my reluctance to avoid revealing everything that transpired over the course of that remarkable year, as the lives of those 3 men, Lauterpacht, Lemkin and Frank, became increasingly intertwined. Suffice it to say that the connections were totally unexpected, a series of happenings which the historian and writer Anthony Beevor describes as being of a kind that quite simply no novel could ever possibly match. The point I'm making is that those personal journeys of those 3 men coincided in ways that produced an outcome that changed the course of legal history, and then, it could be said, of history itself. The ideas and endeavours of Lauterpacht and Lemkin, and of others, influenced politics, history, culture, my life, your lives. The concepts of crimes against humanity and genocide have entered our world and our legal lives, although to many it seems that they were always there. It's extraordinary in talking about East-West Street around the world how many people, very understandably, assume that the concepts of crimes against humanity and genocide existed forever, from time immemorial, but they did not exist forever. Both concepts are the product of creative and inventive minds, of two men driven by their own personal experiences and forged on the anvil of the same city, Lemberg, Lviv. Quite why Lauda opted for the protection of the individual and what caused Lemkin to embrace the protection of the group is, of course, a matter for speculation. I don't know. I can think about it, but I can't know. Their backgrounds were similar. They studied at the same university. They even had, having found their student records deep in the archives of the city of Lviv, exactly the same teachers. Indeed, if you want to trace the origins of these crimes, for those of us who are teachers of law, this is perhaps an interesting exercise, you can trace them to this city of Lemberg. You can trace them to the events that occurred immediately after the end of the First World War and in the short years that followed, and you can trace them into the law faculty at Lemberg. You can even trace the origins to a single teacher the two men had in common, Julius Makarewicz, a Polish professor of criminal law. And then you can follow onwards to a particular building and even to the very room in which Makarewicz taught, sharing his ideas on the treatment of minorities. I found the room, I visited the room, it's still a working classroom. And there is something amazing about being in it and imagining the two men as students sitting on benches of that kind. But even more remarkably, perhaps, despite the two men's common origins, interests, and journeys, despite the fact that on occasion I've been able to locate them in the same city on the same day, it seems that Lauda and Lemkin never actually met. The concepts they put into international law, crimes against humanity and genocide, inform a large part of my working life. My quest to understand Lauda and Lemkin was surely driven in part by my own personal history and by stories that had been buried deep in family crypts, no doubt for the best of protective reasons. Along the way, I conducted more family detective work, and I came across this lady. This is Miss Tilney, and I came to understand exactly what she had done and why my mother and I and my brother have reason to be deeply grateful to this remarkable and courageous human being, who was a missionary working for the Surrey Chapel in Norwich, and who was motivated, it seems, by a single line of chapter 10, verse 1 of Paul's letter to the Romans, a single line that caused her to travel to Vienna and save my mother's life in the summer of 1939, and in the years that followed, the lives of many others. One single act of interpretation. I also uncovered the identity of the man in the bow tie in the photograph that I showed you at the beginning. And that was a journey that took me literally across the entire world, east and then west, across rivers and oceans, through dozens of old Austrian telephone directories, hiring a wonderful private detective in Vienna, and then, of course, finding the answer on Facebook. Ending in an attic in Massapequa, Long Island, just outside New York City, where I found this photograph, which would unlock another family mystery. A single image taken in a garden in Vienna, which I know to be number 4 Brahmsplatz, owned by the Wittgenstein family, in the spring of 1941. It shows my grandmother with 2 men wearing white socks, and I've come to learn what white socks signified in Austria at that period: sympathy for the Nazis. The man on the right was her lover, and one discovery catalyzed another. the identity not only of my grandmother's lover, but the identity of the person who was my grandfather's true love, his closest friend, Max. It turned out, of course, that the man in socks on the right was not a Nazi. He was a secret, hidden Jew, what was called a U-boat in the parlance of that time. Efforts like this can't be rushed. They take years, and they involve the efforts of a remarkable group of individuals. These are the requirements of an exercise in personal archaeological enterprise. And then I learnt even more surprising coincidences, including the rather direct connection between my family and the Lauterpachs and the Lemkins at that period. I was surprised to discover that my great-grandmother, my grandfather's mother, Amalia Flashner, was born and lived in the small town of Żółkiew, the town where Hirsch Lauterpacht was born and lived. Indeed, even more remarkably, I could discover that they were born and lived on the very same street, Lemberg Strasse. Why is that remarkable to me? Because my first teacher of international law, amazingly, was Ellie Lauterpacht back in 1982. And we worked together for more than 30 years before we discovered that we could trace our origins to a single street, the street that the wonderful writer Joseph Roth would refer to as East-West Street, hence the title of the book. But following the research through, I then discovered that Amalia Flashner, who became Buchholz, whose life began in proximity of the Lauterpachs, ended 72 years after she was born in the kingdom of Hans Frank. The last street Amalia Buchholz walked down was called Himmelfahrtstrasse, the street to heaven. It was the street, a short street, that led from the railway platform to the gas chamber at a place called Treblinka. And just a month after she walked down Himmelfahrtstrasse, she was followed by Bella and Joseph Lemkin, who walked down the same street and died in the same gas chamber. So Amalia's life was caught between the Lauterpachs and the Lemkins, as it might be said is mine, albeit in very different ways. How does one begin to explain and understand these points of connection? The ideas of these two remarkable men, Lauterpacht and Lemkin, are of enduring relevance today. The relationship between the individual and the group has been contested across the ages. I was particularly reminded of this when I came across a letter written by Hirsch Lauterpacht to his son Ellie in July 1946. At the time, he was preparing a draft of the closing arguments to be delivered at Nuremberg by Sir Hartley Shawcross, the British Attorney General. Having recently learned that all but one member of his Lemberg family had been exterminated on the orders of Hans Frank, the man he was prosecuting, it must have been a time of intense personal anguish, of personal grief, as well as of professional challenge. It is actually almost unimaginable for me to think about what he was going through. To his son Ellie, he explained that he managed to get through the days and find solace and strength by listening to music, and in particular to the work of Johann Sebastian Bach, and very specifically, the Matthew Passion. Remarkably, at the very same time, in the summer of 1946, the man he was prosecuting, Hans Frank, told Dr. Gustav Gilbert, the US Army psychologist who was attending to his needs and who recorded the fact in his diary, that in these most trying of times as a defendant in this trial, as it reached its climax, he took refuge by imagining that he was listening to music. And he imagined that he was listening to Bach and to the Matthew Passion. How remarkable, I thought, that two men on opposite sides of the same courtroom would find solace in the same piece of music. That act of discovery, incidentally, is the reason that I and my friend, the wonderful opera singer Laurent Naouri, wrote the piece that we perform just 4 times a year, and which some of you, I think, are coming to tomorrow night at Hamer Hall. I immersed myself in research on the Matthew Passion to try to understand why it had a particular resonance for Lauterpacht and for Frank. I've come to understand the resonance for Lauterpacht, who was completely fluent in German. The libretto reflected Bach's emphasis in a pietist belief in the vital place of the individual. Every aria but one in the Matthew Passion is sung as Ich, I, and the 3 landmark choruses are sung in the first person. In this way, I think, Bach was signaling the bypassing of the priest-celebrant and the church, the group, in allowing the individual a direct connection with God. And that would have been significant for Lauterpacht. For Frank, with his scathing disregard of the integrity of the individual, it's more difficult to understand the resonance of the work, not least the fact that it is, in reality, a vicious attack on the Catholic faith, to which Frank had just converted from Protestantism a year earlier, just before the trial began, following a failed suicide attempt. Lauterpacht believed passionately that we should concentrate on the protection of the individual at all times. And he argued throughout his life that Lemkin's invention of the concept of genocide was practically useless and politically dangerous, that it would replace the tyranny of the state with the tyranny of the group. And in a way, my own work, my own practical experience in various courtrooms concords and supports that conclusion. I've observed for myself. How? By focusing on the protection of one group against another, there is a tendency to reinforce the sense of them and us, to amplify the power of group identity and association, which is a source, in a contradictory sense, both of sustenance and of great danger. How does that happen? It happens because in seeking to prove that a genocide has occurred in law, you have to establish the existence and expression of an intent to destroy a group in whole or in part. And I have seen for myself how that requirement reinforces the sense of victimhood of the targeted group as a group and of the perpetrators as a hated group. But I also understand exactly what Lemkin was trying to do. He was surely right in trying to recognize the reality that in most, actually in all cases of mass killing, the targets are not individuals because of what they have done as individuals, but because they happen to be a member of a hated group at a particular moment in time, at a particular place. Lemkin would say, and it's a powerful argument, if not an irresistible argument, that the law ought to reflect that reality, that it must also recognize and give legitimacy to that feeling that most, if not all of us have, of association with one or other groups. And this profoundly strong sentiment was brought home to me very recently when I wrote an article for the Financial Times magazine, a profile of a remarkable German Yazidi Kurdish doctor, Dr. Jan Kizilhan, who is the doctor who established the program to assist so many Yazidi women and girls who were abducted, enslaved, tortured, and then systematically raped by individuals associated with ISIS. Jan Kizilhan is the person, more than any other, who set up the program to bring 1,100 of these remarkable young people to Germany for medical and psychological treatment. He, in his work, identifies a connection between the possibility of justice and the future well-being of victims. Characterizing such atrocities as a genocide is for him a necessary first step. And so he welcomed the use of the word genocide by the European Parliament and the Obama administration in characterizing what was happening in northern Iraq. Calling it a genocide, he told me, recognizes the group's identity, recognizes what is being done to it, and most importantly, recognizes its right to exist as a group. And for him, the implication is clear. Crimes against humanity is simply not enough. But I'm concerned about the hierarchy that has emerged, one that puts genocide atop the list of horrors, so that a mere crime against humanity or war crime is seen somehow as a lesser evil. Call something a genocide and it will always be on page 1 of our newspapers. Call it a crime against humanity, and if it makes it to the newspapers at all, it'll be buried on page 13 or some such place. That is the power of the word you can see on the screen, the word invented by Raphael Lemkin. It is uniquely able in our imagination to conjure up the image of horror. So what's the enduring legacy of these two legal terms? As I said, there was a period of quiescence after Nuremberg, 5 decades passed, and then the catalytic events occurred in the former Yugoslavia and in Rwanda, in the arrest of Senator Pinochet, in the creation of the ICC, in the events of 9/11, and the actions that followed through Afghanistan and Iraq up to today, including the world of ISIS. And today we know, once again, there is a poison of xenophobia and nationalism which has been unleashed and which is coursing its way through the veins of Europe and other places, including the United States. I see that poison on the many journeys that I've made over the last few years to central and eastern parts of the European continent, to Hungary, to Poland, to the Ukraine. Those of you who've seen my film, My Nazi Legacy, will have seen me standing in a faraway field, watching large numbers of people dressed up in SS uniforms, celebrating the creation by Otto von Wächter of the Waffen-SS Galicia Division. It's impossible for me not to have gone through the experience of writing East-West Street, an immersion in the world of the years between 1914 and 1945, and not feel an acute sense of anxiety as to what is brewing. I feel it, as I mentioned, closer to home. One feels in London change in the air, a move to vicious, damaging identity group politics. Brexit and the election of President Trump are surely a reflection too of that unhappy, dangerous, xenophobic, nationalistic direction. We don't know to where it will lead. And so this is the context in which I oscillate between the views of Lauda and Lemkin, between the individual and the group, between the realism of Lemkin and the idealism of Lauda. I can see the force of both arguments, and I can recognize too the tension and the struggle between the individual and the group, between crimes against humanity and genocide, and why international law today embraces both concepts. Those of you who've read East-West Street will know that I end the book standing at a place of long ago mass killing, caught between two poles, between my head and my heart, between intellect and instinct, recognizing the need to value the inherent worth of every human being, but understanding too that pull of tribal loyalty, and recognizing very directly the essential truth of the notion that we are indeed haunted by the gaps left within us by the secrets of others, but also by the possibility that the discovery of the existence of such a haunting, to know of it, will not necessarily destroy us, but could, perhaps, actually make us stronger. Thank you very much.
Before I thank Philippe on all of our behalf, we've got some time for questions now. I'm just going to ask people perhaps to identify themselves before they ask the question, but also to wait until one of our intrepid microphone bearers reaches you. So we've got a few minutes now, so I'd invite people to ask questions.
Hello, I'm just a reader of your book, which I thoroughly enjoyed, and I'm interested in what you said about perhaps the downsides of genocide as a crime, and what sort of things might be put in place to still allow that to be a crime, but to also overcome the adverse impacts. Would things like truth and reconciliation assist in doing something to take away that conflict between the groups?
No, I mean, it's a huge question, which I've just spent now years thinking about, and which I think, to be honest, I'm not really any closer to resolution on. I end the lecture by saying, look, I understand what Lemkin did, and he was right. The word genocide exists, it's not going to disappear, it's with us forever. The question is, what do we do about its unintended consequences? And I have seen for myself, in some of the cases I've litigated, that the unintended consequence of the concept of genocide appears to be to reinforce and make more likely the very acts it is intended to prevent. That is the unhappy place I've come to. What do we do about it? Well, one option is to do what Lemkin did, which is to lower the threshold. For Lemkin, if you had a small village of 9 people, 3 from each of 3 groups, and 2 of the groups gang up on the 3rd and kill the 3 people, that's a genocide. He wasn't interested in numbers. For him, it was the intent and the consequence of acting on that intent. So one possibility would be to regularize the concept of genocide so that there would be in law many more genocides. But there's no desire at all to do that. I tried that in a case at the International Court of Justice and was completely slapped down by the judges, made no progress at all. They want to keep it up there in that way. And it leads to just absurd situations. Let me give you an example. In the UK, I think as here, in January each year, there's something called Holocaust Memorial Day. And in the UK, the way it's done is it marks not just the killing of the Jews in the period 33 to 45, but other terrible acts of killing. And there was an academic meeting to which I was invited a couple of years ago. And at one point I asked, how do you decide which other acts of killing you mark? I mean, there are so many. How do you decide? And they said, oh, we have a formula for that. The Foreign Office has a formula. Firstly, it has to be after 1945, which is, of course, hugely convenient because it excludes things like Armenia, British colonialism, etc., etc. And secondly, an international court must have ruled that the act of killing is a genocide. Oh, I said. So just to help me understand, 8,000 people killed at Srebrenica you will mark, but 3 million people killed in the Democratic Republic of Congo you'll just say nothing about. Correct. What's the point of that? I mean, it creates a sort of hierarchy, a sort of Premier League of horror in which certain people are recognized and others are forgotten. And I was just told, well, we have to find a working method to deal with it. So there's a problem. There's plainly a problem. Prosecutors at the various international courts will tell you that all victims want their crime to be called a genocide. They don't want it to be a war crime. They don't want it to be a crime against humanity. for exactly the same reason. So this hierarchy has been created, which I think is very problematic. But the definition is necessary. What would I do? If you were starting completely from scratch, I'd merge the two concepts into a single concept. I'd have basically just crimes against humanity aggravated by sort of racially motivated intent to destroy or harm a particular group or groups. But it seems that it is too late for that. And the word, that Lemkin invented, it's out there, and there's no putting it back in the bottle. So we have a problem. We have a real problem.
Thank you very much for very, very great exposition of your book, which of course I read with great interest. My name is Anne Fink. I'm an anthropologist. I think there's an elephant in the room, and I was wondering if we could address it. When you said that one of the actual conditions of genocide would be intentionality, if I understood you correctly, the intention to destroy a group. How many people have to say it, and who has to say it? And I'll say it quite straight. There have been a number of members of Knesset in Israel who have announced their intention to destroy the Palestinian society. And I was wondering, when does this word apply, and when is it a crime against humanity, and are we allowed or not allowed to talk about it?
So it's very difficult in practical terms to prove intention. I mean, I'm not going to comment on any particular examples. Lots of leaders say things. Do they actually intend to act upon them? It's complex. But generally, those involved in mass killing tend not to leave bits of paper around saying, oh, and I'm doing this in order to destroy the group. I mean, that's my intention. They've learned the lesson. I mean, that happened from 1942 onwards, certainly, after the Wannsee Conference. And so you won't find those bits of paper, and so you are left to infer intention, in large part, from a pattern of behaviour, which is very difficult and leads to what I think are rather crazy situations. So you can have the same people involved in acts of killing on two different sides of the border involving two different communities in relation to Srebrenica and Vukovar. The Yugoslav War Crimes Tribunal has characterized what happened in Srebrenica as a genocide, but what happened on the other side of the border, just a few kilometers away, largely the same perpetrators, directed by the same people, quote unquote, only a crime against humanity. And that has caused, between Serbia, Croatia, and Bosnia, huge ructions and huge difficulties. Why did the Bosnians get a genocide, but the Croats didn't? And I'm absolutely clear, having spent a lot of time in that region, that this will come back to haunt in 20, 30, 50, 100 years. I mean, these are areas where communities and individuals have long, long memories. When we drafted, I was involved in the case at the ICJ for Croatia against Serbia on Vukovar, where I tried to run a different argument on genocide and lost completely. I remember when we drafted the first pleading, which is called a memorial, sitting in London, we thought, oh, where should we start telling the story? We'll start telling the story in 1986 when Milosevic has his plan for a greater Serbia. We produced what we thought was a decent enough draft, sent it off to Zagreb. And it comes back, or at least we go to Zagreb, we meet with the Prime Minister's office. No, you don't start the story in 1986, you start the story in 1373. And the same if you talk to the Yazidi community, they will tell you that the acts of genocide against them go back 3,500 years. So, I mean, I'm not skirting around the vital question that you're asking. What happens is a judge or a group of judges have to form a view whether, on the basis of the evidence before them, they can show that the individual perpetrator intended to destroy a group in whole or in part. It's a very, very difficult thing to do. The acts of killing are not done by the political leaders. The political leaders adopt statements, make resolutions, say things, and then people who are lower down on the scale go and do the acts of killing. What's the relationship between those two expressions of sentiment or action? To what extent can you write in to what the actual killer does, what the leader who told him or her to act in that way intended? I mean, it's just fraught with difficulty, which is another reason why I would like to find another way to address these issues. Or putting it another way, I mean, why should the killing of 100,000 people as a crime against humanity come to be seen as a lesser evil? If 100,000 people die, or 10,000 people die, or 5,000 people die, what does it matter what label you give it? And yet, if you speak with communities, and there will be some here in the room, these things are, for many other reasons, vitally, vitally important. But there is, beyond the problem I described about the consequences of characterizing an act as genocidal or not in law, the problem that you focus on: how do you prove intent? There are a few criminal lawyers in this room, more than a handful, who know exactly what I'm saying. It's fantastically difficult. And in effect, you create a situation in which the accident of history, who leaves the bit of paper around, who says something as they're engaging in an act of atrocity, who writes something on a wall, that could be sufficient to get you to genocide. For policy purposes, what is the social utility of that distinction is the question that I would ask.
Well, I think it's probably more just a comment, but I think that there's a question about whether there's a moral difference between the two. And it sounds to me like it's almost a PR problem, that somewhere along the line someone has decided that genocide is worse than a crime against humanity. And I guess I also can't see a reason other than history and politics why we would be in that position.
I mean, I think you look at the two words, or two terms. Words really matter. They really, really matter. The term crime against humanity, it has a sort of technical, legal component to it. You look at those words and you understand that it's bad, but it doesn't open up your imagination. It doesn't allow you. I mean, I'm not really answering your question about the moral side. I think there's something else that is going on here. And yet the word genocide has an effect on people. I know from having given now several lectures where you show Lemkin writing out that word, the first time I used that animation, which was made for me by a friend in Washington, I know from what people said afterwards coming up to me after the lecture that they were just, it affected them deeply to see that word being written out in his hand. How do you explain that? I can't explain it. I mean, it's out beyond my pay grade to be able to explain why that word produces the effect that it does on so many people. What is the magic of the term? And the thing that is interesting, for those of you who've read the book will know, is Lemkin didn't just invent it in a second. When I was in the library at Columbia University with his archives, he's got pages and pages where he's trying out all sorts of different formulations. There's one sheet of paper that I reproduce in the book where he writes out more than 25 times the word genocide and then crosses it out and tries other formulations. So he wanted a word that would produce effects in its reader that went beyond the normal technical legal language, and he succeeded. But why he succeeded, I can, like everyone else in this room, only begin to speculate why that word has the consequences that it does and the effect that it does, whether in law or in morality. And to be clear, there is a public perception of what genocide is, which is different from a legal definition, but no less significant, no less valuable, no less important. Genocide for most ordinary, intelligent people is terrible acts of mass killing. Doesn't focus on special intent, doesn't focus on numbers. For many people, what happened in the school last week in the United States is a genocidal act because it describes an act of horror and of mass killing. So on a moral level, there are many genocides. In law, there are very few.
At that point, call it the form part of the proceedings to a halt. People do have the opportunity of listening to, watching the performance tomorrow night, I think, at Hamer Hall, which will, I guess, give a new language to some of the points that you're making. But
the difference is that it has music, and what I've learned, which is really interesting, that I had not appreciated, is you can speak words and they will have consequences. Speak the same words accompanied by music and they have totally different consequences. And I'm really trying to work out why it is that the melding of words and music produces a reaction in the human person that is so markedly different. I don't have an answer to that question either.
This is just a whole new legal curriculum I think we can give to our new dean. I should have said I'm Hilary Charlesworth, and it's my great pleasure to have this opportunity on your behalf to thank Philippe Sands. And I was wondering before the lecture, after, I think like many of you who've read East West Street, I was wondering how Philippe would in just an hour manage to capture the essence of his brilliant but sprawling book. Of course, it's not just one book, it's several. There's, as you've seen, it's a family history. There's the biographies of Lemkin and Lauda and Frank and so on. And then and we've had a very good flavour of that, the really interesting, complicated, controversial legal analysis. And of course, it has become, I think, to most academics, an entirely extraordinary phenomenon in that it's accompanied by a film, there are stage performances, there is music and so on. So it's an extraordinary skill I think, to have given us a flavour of that in just an hour. And we've all had the great pleasure of seeing Philippe's curiosity and energy and creativity on display in unfolding the really intricate and remarkable work. I think what I've taken away from tonight is the way that you've shown us how the study of law can be illuminated by paying attention to the details of personal biography and human relationships. And the idea, I think the implication of what you say is that so many different histories could be told, the idea that there's no single objective history of any events available. And this is very much, I think, echoed in the words of Hilary Mantel last year in her Wreath Lectures when she said, we don't reproduce the past, we create it. I think you've really shown this in many different ways. So thank you, dear Philippe, for taking us this evening on this wonderfully intriguing journey between, as the words you ended with, I really love them, the poles of head and heart, of intellect and instinct, and showing us both the porosity and the power of law. And with that, please, Steve.